Good evening, students. My name is Girish, a renowned faculty of UPSc. Today, we are going to discuss about an article regarding reforming the process of judicial appointments, which has been published in The Hindu on September 2nd, 2024. Okay, let's jump into the topic. So, first of all, why this topic was in the news is because, as we can see, in April itself, by April 2024, as of April 2024, 60 lakh cases are remained pending at various high courts, while 30% of the seats have remained vacant. So 30% of judicial seats have been remained vacant, and 60 lakh cases are pending as of April 2024. So why there is a huge pendency of cases and what causes this problem has been discussed in this article at length. So this article talks about that the problem of pendency of cases has been clearly linked with the problem of appointment of judges. So we will be discussing today about this process of judicial appointments, what is collegium system, and what are the arguments which are favoring judicial what are the arguments that are favoring this collegium system, what are the arguments that are against the collegium system, and we'll also try to learn, as per this article, what are the lessons that we have learned from other countries, and how we can revamp the NJAC, and what are the suggestions and way forward is what we are going to learn in this article. Right. So first of all, we will be learning what is collegium system. So as definition says, it's a mechanism which has been devised to ensure a democratic system of appointment and transfer of judges. So for the process of appointment and for the process of transfer of judges, there is a mechanism in this democratic system which has come into existence through second and third judges cases judgments we will be discussing successively. So what we should learn is there is no such law or constitutional provision that mentions or defines the collegium system, which is very, very important to know for your UPSC prelims. Like, there is no constitutional provision which mentions or defines the collegium system. Next, we will learn that is the collegium system which has been part of the constitution or not, whether it has been mentioned directly or indirectly, is an intrinsic part of the constitution or not. Yes, the collegium system is kind of an intrinsic part of the constitution as mentioned in Article 124 Clause 2. In Article 124 Clause 2, it says that every judge of the Supreme Court is appointed by the President of India. So who appoints the judge of a Supreme Court? As Constitution says, it is appointed by the President of India with the consultation of Supreme Court and High Court, with the consultation of Supreme Court judges in the case of Supreme Court. In the case of High Court, it will be consulted with the High Court judges. Okay, so I am coming again. So how a judge is appointed in the Supreme Court? So every judge of the Supreme Court is appointed by the President of India in consultation with the judges of the Supreme Court. Even there is a mention of article called as Article 217, where High Court judges will be appointed by the President after consultation with the Chief Justice of India and Governor of the respective state. So how High Court judges are appointed by the President of India after consultation with the Chief Justice of India and the Governor of the state. Even the Chief Justice of the High Court should also be consulted. The Chief Justice of the concerned High Court will also be consulted while appointing the High Court judges. Oh. So this is what that has been mentioned in Article 124 Clause 2 of the Constitution and Article 217 of the Constitution. Next, so we will be tracing the evolution of the collegium system, which has been evolved over time through a successive judges cases called as first judges case, second judges case, and third judges case. So we will be learning what are these actual processes that has been gone through this by this apex court, and various changes have been effected. First we'll learn about first judges case. This is also called as SP Gupta versus Union of India. This case, first judges case, is also called as SP Gupta versus Union of India. This is a 7-judge bench case. This is a 7-judge bench case which has held that the President of the India, so please listen carefully, that the President of India, who is head of the executive, is the final authority to appoint. The President of India, who is also the head of the executive, is the final authority to appoint, and he need not follow the judges. He need not follow the advice of the judges. So what in SP Gupta versus Union of India, which is a case which has been decided by 7-judge bench, it has said that the President, who is also the head of the executive, is the final authority to appoint the judges, and he need not follow the advice of the judges whom he consults as per Article 124 and Article 217. It is saying that the President may be consulted with the Supreme Court judges, but the consultation is not bound upon the President, and the President is free to decide upon the appointment of the judges. That is what in SP Gupta versus Union of India it has said, which means the clear wording of SP Gupta versus Union of India is, it means consultation is not concurrence. That means the President may consult with the other Supreme Court judges for the appointment of Supreme Court judges, but the consultation by the President of India, no need to concur with the advice that has been tendered by the other Supreme Court judges while he is making the decision. This is what which has been mentioned in first judges case. Hope I am clear. Which is also called as SP Gupta versus Union of India case. We famously call it as first judges case, which has been decided by the 7-judge bench. What it has said is, I am reiterating it, that President is the final authority to appoint the judges, who is also the head of the executive, and when President is consulting the other judges while appointing the judges, he no need to concur with them. He no need to concur with the decision of the judges. He no need to comply with the advice of the judges. He can just make a decision on his own. Next, we'll jump into the second judges case. The second judges case is also called as Supreme Court Advocates on Record Association versus Union of India. The second judges case, which has happened in 1993, is also called as Supreme Court Advocate on Record Association versus Union of India. It has said that this is a 9-judge bench case. This is a 9-judge bench case. And this case is a landmark case. It has also overruled the decision that has been given in SP Gupta case. This has overruled the SP Gupta case judgment, and it has devised a specific procedure called as collegium system. So the collegium system has been evolved in second judges case, also called as Supreme Court Advocate on Record Association versus Union of India, and which has devised this specific procedure called as collegium system for the appointment and transfer of judges in higher judiciary. For the appointment and transfer of judges in the higher judiciary. And this case it has overruled with the majority of 7 is to 2. This case has overruled the previous SP Gupta case with the 7 is to 2 judgment. And the court held that the Chief Justice of India should play the primary role in appointment of judges. What in second judge's case it has said that the Chief Justice of India should play the primary role in appointment of judges, and it also interpreted consultation means concurrence. It interpreted that consultation means concurrence. This system relies on collective opinion of CJA and senior most judges So this collegium system relies on Chief Justice of India and senior most judges rather than an individual opinion like president. Okay, rather than an individual opinion in the case of president who is making the decisions in the process of appointment, this collegium system has said that the Chief Justice of India should play the primary role in appointment of judges, and along with the Chief Justice of India and the senior most judges will also be taking part in this collegium system. So in the process of judicial appointments. Okay, so in the process of judicial appointments, this is how the second judge's case has said. And definitely now the power of the president has been reduced. And the power to the CJA and senior most judges, which is collegium system, has evolved. Next, there comes a third case called as third judge's case. So this is one more landmark case called as third judge's case in the process of appointment of judicial appointments, which has happened in 1998. So in this context, a nine judge bench in third judge case, they have reaffirmed the decision. Okay, they have reaffirmed the decision that has been made in the second judge's case. They have reaffirmed the decision that has made in the second judge's case, and the court held that the recommendations for judicial appointments should be made by CJI, Chief Justice of India, and in consultation with four senior most judges of Supreme Court. So what in third judge's bench case, they have said, the 9 judge benches have said that they have reaffirmed the decision made in the second judge's case, and the court held that the recommendations for judicial appointments should be made by Chief Justice of India in consultation with 4 senior most judges of Supreme Court. And this ruling firmly established the collegium system. Where the collective opinion of CJI and senior judges became binding on the government. Okay, so whatever the decision that has been tendered by the CJI and 4 senior most judges in the process of judicial appointments have been made binding on the government. Okay, so the CJI and 4 senior most judges opinion have been made binding in the third judge's case on the government in the process of judicial appointments. So that is third judge's case. Next, so to solve this, appointing judges and this collegium system has been criticized by numerous what we call lawyers, advocates, and it has been criticized internationally. So to solve this, there is a commission, the parliament with the with the deliberations that has been made with the law commission, they have inscribed this National Judicial Appointments Commission in 2013, and it was like lapsed. I guess it was lapsed in 2013 due to the dissolution of Lok Sabha in 2013. And again, the new government in 2015, they have introduced this NJAC bill, and which has really passed. Okay, this NJAC bill has passed in 2014 itself, the NJAC, and it has become NJAC Act 2014 under 99th Constitutional Amendment Act. So the NJAC was proposed from the following after the recommendations of National Commission to review the working of Indian Constitution, which has been introduced by UPA government in 2013, and it was lapsed due to dissolution in Lok Sabha. Again, it was introduced by the new NDA government in 2014, and it was passed. NJAC was passed through through the passage of 99th Constitutional Amendment Act. So what this NJAC Act, National Judicial Appointments Commission Act? This NJAC, it would be consisting of Chief Justice of India as the chairperson, two senior-most Supreme Court judges, Union Minister for Law and Justice, Union Minister for Law, and two eminent persons nominated by a committee which comprises of Prime Minister, Chief Justice of India, and Leader of Opposition. So these 1 plus 2 3 4 and plus 2 6. So this 6-member committee, which is headed by a Chief Justice of India, obviously as a chairman. So this 6-member committee, instead of collegium system, these 6-member committee would advise the government. Okay, they would advise the government on the process of judicial appointments. Okay, in the process of judicial appointments, these 6 members would be suggesting. But there is one more case, a famous case, 4 judges case has evolved. So what this 4 judges case? One second. Okay, so what this 4 judges case? This 4 judges case, which has happened in 2015, the constitutional validity of NJAC, that is 99th Constitutional Amendment Act, was challenged in the Supreme Court, saying that because Article 50 of the Indian Constitution of Directive Principles of State Policy, what it says, separation of judiciary from executive. So separation of judiciary from executive, that is what Article 50 calls for. So which is also kind of basic structure of the Indian Constitution, which is separation of powers. But 99th Constitutional Amendment Act, what it says, that is executive now appointing the judiciary. Executive is appointing the judiciary. So which is violative of Article 50, which has been, that is what the lawyers have been like pointing out. So they have challenged. Okay, so they have been challenged in the Supreme Court, and with the 4:1 decision, in the Supreme Court, both the act, the NJAC Act, and the amendment, okay, the 99th Constitutional Amendment, has been made unconstitutional, saying that which is violative of Article 50, that is separation of judiciary from executive. Executive cannot appoint the judges. So okay, so the court has cited that the inadequate and the court has also cited that inadequate judicial representation in NJAC. Okay, the inadequate judicial representation in NJAC, even though the act has said that Chief Justice of India as a chairman and 2 more senior Supreme Court judges, but the act has said that there has been inadequate judicial representation in NJAC. And the involvement of executive members and the involvement of executive members as union minister for law, prime minister, leader of opposition. So the involvement of executive members has violated the principle of judicial independence. Okay, so what the court has said, it has violated the principle of judicial independence, and basic structure of the constitution has been violated. So on this pretext, they have they have made this NJC Act and 99th Constitutional Amendment as null and void. So this is all about the evolution of collegium system. This is all about the collegium system. Right now, the third judge's bench's case has been prevailed, where the collegium system is consisting of one Chief Justice of India, who is assisted by foremost Supreme Court judges, and they are deciding upon the judicial appointments, and they are making their decision to the president, and which is binding upon the government to make the decision. So this is what now the collegium system has prevailed. So that's it. I mean, we will be learning what are the arguments in favor of the collegium system in India, and what are the arguments against it. Okay, quickly, what are the arguments in favor of the collegium system? Yes, there are definitely, a coin has both the sides. So we can be saying that even the arguments have some favor. This collegium system also have some favor. It upholds judicial independence. Definitely, it upholds judicial independence because the collegium system ensures that judges appoint their peers. Okay, so because judges appoints their peers, it maintains judiciary's independence. It maintains judiciary's independence from the executive branch. So that's Article 50 is being upholded, separation of judiciary from executive is getting upholded, or which is the basic structure of the constitution. Okay, so judiciary's independence is upholded because judges are appointing their peers itself. So, and it also is yes, definitely we can argue that this definitely prevents political interference. Okay, so by judges appointing judges, definitely we cannot ignore this point, political interference. Okay, so the political interference will be lowered. This prevents political interference in judicial decisions. Safeguarding, it also helps in safeguarding rule of law. It also helps in ensuring fair justice. So these kinds of things are definitely upheld. Okay, so we cannot ignore this point of ensuring judicial independence, which is very, very important, because judiciary is kind of a bulwark of the Indian Constitution. So to rule of law, to ensure fair justice, we need judicial independence. We need this. Next, definitely prioritizing merit and experience. This is one point I cannot ignore, because judges are selected based upon qualification, experience, their judicial acumen. So these are the points that will be selected based upon, and definitely these are some kind of factors that are considered beyond academic credentials. Okay, so these are some kind of factors which are beyond academic credentials. We cannot ignore them. This is what the collegium system will critically evaluate all the candidates. Okay, so this ensures that the most competent and experienced individuals are appointed to the bench. This is what the collegium system is doing the great thing. Even this is next, sorry, promoting diversity and inclusivity. The collegium system has been instrumental in promoting the diversity within the judiciary. So how can you argue this? Yes, sir, definitely we can argue, sir. It has led to the appointment of judges from various backgrounds, including we have women justices. We have people from marginalized communities. We have people from backward regions. This ensures that the judiciary reflects the diverse nature of Indian society. This ensures definitely that judiciary is reflecting diverse nature, and judiciary is not narrowing itself. It is fostering public trust. Okay, it's ensuring public trust by maintaining this kind of diversity and inclusivity. Even I can definitely give you one good example about Justice Leela Seth. Okay, there's a woman. Okay, she's a woman, Justice Leela Seth. She is the first Chief Justice of High Court in India. She is the first Chief Justice of High Court in India. First women Chief Justice. I'm sorry, first women Chief Justice of High Court in India, and see, which is a testament to the system's commitment to exclusivity. Even we are very proud that B.V. Nagaratna, B.V. Justice B.V. Nagaratna, she will be becoming Chief Justice of India in 2027. So, the first women Chief Justice we are going to have in 2027, I am very proud to say this. So, this is what promoting diversity and inclusivity means. Next, ensuring institutional memory and continuity. Just say the collegium system, with its reliance on senior judges, it allows for the preservation of institutional memory and the continuity of judicial practices and precedents. Okay, so this kind of precedents, this kinds of conventions are need to be practiced, because this can be a particularly important in a complex legal system like India, where the interpretation and application of laws often evolve over time. The collegium's ability to maintain a consistent approach to judicial appointments has helped to ensure a smooth transition of power within the judiciary. Even during periods of political instabilities or changes in government, the judiciary has never withered. It has stand its time. It has stood its time. So ensuring institutional memory and continuity is very very important. So that is where the collegium system, with its practices, precedents, by conserving all the practices and precedents, this collegium system is handy. Yes, as I said before, like even the argument, we have arguments in favor, we have arguments against. So we'll be learning what are the arguments that are against the collegium system. So, even often criticized that this collegium system uh, was lacking transparency. How can you say this? I mean, like, see, the collegium system has been criticized for its opaque decision making process. Sir, before we know that collegium system exists, but really do we know that how the processes happen, how the processes happen, how the justification for the appointments were made, on what is the yardstick, what is the basis of appointment. I mean, is this decision making process open to public scrutiny? So we don't have this kind of information. Like, the process of decision making in the collegium system is very opaque, and what are the parameters that are being taken by this collegium system while selecting the candidates? We know nothing about this. Okay, so we only know that only credible candidates are coming, but we know nothing about this decision making process, which is like not an appreciating factor in this democratic system. See, everything has to be in the public scrutiny. What are the yardstick, what are the measures that you are taking, how they are, on what basis, what is the qualification, how you are making the justification to the appointments, should be made very clear by the collegium system while appointing. So this lack of transparency uh, is really undermining the public trust in the judiciary, and these are really raising concerns about the fairness and integrity of the selection process. So when there is a questions which are the eyebrows are raising, the questions are raising regarding the fairness and integrity of the selection process, is which is really kind of like a thing. I mean, we can say that collegium system has really failed in this. Like, for example, I can definitely I cannot figure out this, like how a Saumitra Sen. Okay, so Saumitra Sen was really appointed as a Calcutta High Court judge in 2003, I guess. Yes, Saumitra Sen was appointed as a Calcutta High Court judge in 2003. Even there is a kind of a, despite there are allegations, yes, there are some kind of allegations where that fund misappropriation has been happened in his time as a court appointed lawyer. So when there are some kind of misappropriation allegations have been there against this kind of person, how can he be appointed uh, as a Calcutta High Court judge? So these are rising the questions regarding the collegium system. Next, even collegium system, because of this uncle judges syndrome. What is this uncle judges syndrome? Like the collegium system, because of its opaque decision process, closed door deliberations, and relying on senior judges. Because of relying on senior judges, this is raising eyebrows. Like it can lead to nepotism. Okay, it can lead to nepotism. It can lead to cronyism. So there may be like concerns that personal connections, loyalty can play a role rather than merit, rather than in the process of selection. See, so when even I can remember that even Law Commission of India has also said that in one of its report, it has also highlighted that there are kind of issues and lacks of checks and balances in the process of appointment of judges, that is like in the collegium system. So when Law Commission of India in its report it is criticizing, somewhat there is a kind of reality in this. Okay, and maybe lack of diversity, like collegium system is definitely criticized for its failure, even though the collegium system is like promising diversity, but it couldn't deliver. How, like it was like it's really failed to promote greater diversity within the judiciary, particularly in terms of gender, caste, and regional representation. It couldn't do this. So the dominance of senior judges from certain backgrounds, like high caste backgrounds or high class backgrounds, may result in a judiciary that really does not adequately reflect the diversity of the Indian population. Next, last but not least, the lack of external oversight and input. Like the collegium system operates without any external oversight. Like for example, like no stakeholders such as public, legal experts, or civil society organizations have been taking part in this decision making process, and they are like insulated from this broader perspectives. So this is what these are the robust arguments that we can make against the collegium system. Nonetheless, but just as in the article that has been mentioned, what are the judicial appointment mechanisms that are differing across the countries? So, yes, there are some international practices where we can definitely inspire from, we can definitely adopt them in this process of judicial appointments. First, if we take in the process of appointment process of United States of America, the federal judges of USA are appointed by president. Okay, the federal judges are appointed by the president with the advice and consent of Senate. With the advice and consent of Senate, the president is appointing. So even USA has a rich practice of this appointment of federal judges by the president, which is like advice or consent of Senate. Obviously the candidates need to undergo assessment by a committee of American Bar Association, and it is also reviewed by Senate Judiciary Committee before a Senate vote. So these all are there, but yes, president is appointing the federal judges. That's what this is the rich practice, this is the rich heritage that what USA has. Even uh, when we come to Canada, South Africa, and various US jurisdictions, these countries have an independent judicial appointments commission system. Okay, these countries utilize an independent judicial appointments commission system, which is well regarded for its effectiveness. So why can't India have national judicial appointments commission, is what this article is asking us. So we can make some kind of changes in NJSC, and we can also practice this rich practices of South Africa or Canada and all. Yes, but why can't we are able to do this? And because there is rising pendency of cases and rising pendency of judicial vacancies. So that is what the author is making the strong voice. So last, so what are the changes that could enhance the existing collegium system is what he is suggesting in the article. First one is enhanced transparency and accountability. So what, how do we enhance this? So the collegium system, as we were criticizing the collegium system regarding the processes of appointments as the opaque decision making process, we don't know what are the yardsticks, what are the qualifications that are being made to select the candidates. So the collegium system can be made more transparent to increase even the public trust, public scrutiny can be done. So a clear guidelines, okay, a clear guidelines and procedures for judicial appointments should be established, right? Clear guidelines and procedures for judicial appointments should be established, and public consultation should be incorporated, okay? Public consultations should be incorporated into the processes. This would ensure that judiciary is accountable to the people it serves, right? So that is how we can definitely ensure transparency and accountability. What? Collegium system should have clear guidelines and procedures for judicial appointments. Okay, next, what should be the role of the executive and how can be the role of the executive? Yes, while judiciary, definitely there is no doubt about it, judiciary should maintain its independence. The executive branch should also have a greater role in judicial appointments, as we have seen that in foreign countries like South Africa, Canada, and various US jurisdictions, they have independent judicial appointments commission. Then why not India? So a revised National Judicial Appointments Commission is what is suggested by the author. It is also saying that while revising the NJSA, incorporating representatives from judiciary, executive, civil society organizations, it could strike these three. When we include all these stakeholders from all these multi diverse communities, it could strike a balance between judicial independence and accountability. Okay, it could strike a balance between judicial independence and accountability. So a wonderful suggestion has been made of how a revised NJSC can be made, how judiciary, executive, and civil society organizations, all the stakeholders can be involved in this process of revising it. Even next, definitely see, we should have this because this would definitely prevent the judiciary from becoming overly powerful. Only when we are giving the uh, uh, key or the remote to the hands of judiciary, it is becoming overly powerful. So ensuring appointments based on merit and public interest are the need of the hour. Next, merit based appointments. Yes, definitely, merit based appointment criteria for judicial appointments is the need of the hour. Okay, qualifications, experience, and judicial acumen should be the primary considerations while selecting a candidate. No other thing, kind of like nepotism or such, they does not have a place in democratic systems like India. So judiciary's efficiency and effectiveness will also be enhanced only if we have the candidates on the basis of qualifications, experience, and, as I told you, judicial acumen. Next, even see, the process point is time bound appointments. We don't have time bound appointments, we are delaying the judicial appointments. So to address this delay in judicial appointments, strict timelines should be established for the collegium processes. Strict timelines should be established for the collegium processes, which would prevent vacancies from persisting for extended periods, for like months, years, and all. It definitely ensures that judiciary is fully staffed and able to handle the case loads efficiently, because like there is numerous pendency of cases. I can definitely remember that 86% of the cases are pending in subordinate courts in India, 12% of the cases are pending in high courts, and 2% of the total cases are pending in supreme courts. So nonetheless, like because of judicial appointments, because of the delay in the judicial appointments, and we don't have kind of any strict timelines that should be done, this is the case. So a time bound appointments of the members, and we need to have a strict timelines for the appointments of the collegium system. Next is public participation. Yeah. Last but not the least, the judiciary should actively seek public input in the judicial appointments process. This could be achieved through public consultations, or online forums, feedback mechanisms. So through all this, definitely it would help judiciary as a responsive to the needs and expectations of the people itself. That's it. I mean, public participation is the need of the hour, which would definitely ensure its credibility. The credibility of the judiciary as an institution would definitely increase in the eyes of the public. So definitely these are very 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 good solution that we can definitely suggest. So this is what the author is saying, that like attaining the equilibrium is vital for maintaining the rule of law, public confidence. In India, delayed justice is all too common, and we need to think of ways of preventing it. So, this is how the author has concluded. So, revising the NJAC or adopting the similar reforms could help resolve these challenges and improve the overall functioning of the judiciary. So, hope I made very clear regarding the process of judicial appointments, what is collegium system, the evolution of the collegium system, what are the arguments that have been made for the collegium system, what are the arguments that have been made against the collegium system, and last but not the least, what are the suggestions that we can, what are the practices that we can inspire from the foreign nations, and what are the suggestions that we can make for the process of judicial appointments, like reworking NJAC and all. Thank you for listening this article very patiently. Jai Hind.